Hello and welcome. This filing was submitted by the Karen Reed defense team today, April 2nd, 2025, and you can see on the far right-hand corner, it is stamped for April 2nd. It reads, Defendant's response to Commonwealth's renewed motion in limine to exclude expert testimony of Garrett Wing. Now comes the defendant, Karen Reed, Miss Reed, or defendant, in the above captioned matter, and respectfully requests this court to deny the Commonwealth's renewed motion in limine to exclude expert testimony of Garrett Wing. There's a footnote number 1. We will read it in a moment. It continues, the entirety of the Commonwealth's renewed motion appears to be based upon the inaccurate premise that the defense intends to call Lieutenant Garrett Wing as a surrebuttal expert to Commonwealth expert witness Dr. James Crosby, Dr. Crosby. In actuality, the defendant intends to call Lieutenant Wing as an expert witness in her case in chief and not as a rebuttal witness to Dr. Crosby's testimony. On this basis alone, the Commonwealth's motion should be denied. Excellent work by the defense. We all know by now, guys, pulling away from the motion, we all know by now how Hank Brennan twists everything around, right? He calls the truth lies, and he calls lies the truth, and he misrepresents where the defense is coming from all the damn time. And this is yet another example of Hank Brennan misrepresenting and mischaracterizing what the defense was asking for. So excellent work for the defense to immediately bite back and say, the prosecution is wrong. He's not a surrebuttal expert. He is an expert defending Karen Reed's argument. Continuing, as the defense has stated previously on June 18, 2024, this court determined that only a medical doctor could opine on the medical cause of an injury to a human. Boom. Excellent work, defense team. And guys, if you're following this case on social media, you know that a lot of Karen Reed supporters pointed out Judge Bev's hypocrisy, how she didn't let the ARCA experts testify as to the wounds, as to John O'Keefe's wounds, because they were not MDs, they were not medical doctors. And this is the defense throwing her words back at her. I'm going to read it again. As the defense has stated previously on June 18, 2024, this court determined that only a medical doctor could opine on the medical cause of an injury to a human. Until March 6, 2025, the defense therefore operated under the impression that only medical doctors are able to testify as to the medical causation of an injury to humans, including injuries caused by dog bites and or claw marks. I'm going to read the footnote back up here on page 1. It reads, defendant does not waive and reserves any argument put forth against Commonwealth's original motion in limine to exclude expert testimony of Garrett Wing. Excellent. You see, they're covering all basics because we know how sneaky this prosecution has been. Continuing, this court's March 6, 2025 order caused the defense to revisit the topic of the wounds to the right arm of the decedent, including potential witnesses expert in dog-inflicted wounds on humans who are not medical doctors. At no point did the defense ever express that Lieutenant Wing is intended purely as a rebuttal witness for Dr. Crosby, rather that the court's determination on Dr. Crosby, including the defense's motion for reconsideration of the March 6th order, would inform defense strategy regarding Lieutenant Wing. Additionally, until the March 6th order, several questions remained about how the defense would proceed relative to the Commonwealth's treatment of Dr. Crosby. At oral argument on March 4th, 2025, the Commonwealth verbally stated that it did not intend to call Dr. Crosby in their case in chief and intended only to call him as a rebuttal witness against the testimony of defendant's expert, Dr. Marie Russell. The court asked, so just to be clear, the Commonwealth does not intend, if I permit the testimony, does not intend to call him in your case in chief, ? End quote. The Commonwealth responded, quote, absolutely not, end quote. Commonwealth renewed motion, docket number 658. However, the court's March 6 order contained no such limitation on the scope of Dr. Crosby's testimony for the Commonwealth to call him only as a rebuttal witness. Excellent work, guys. This is the defense analyzing as they should be and pointing out the prosecution's, again, misrepresentations. They are leading by misleading. They are leading with lies. And Judge Bev is allowing them to. So I'm going to read that part again. At oral argument on March 4th, 2025, the Commonwealth verbally stated that it did not intend to call Dr. Crosby in their case in chief and intended only to call him as a rebuttal witness against the testimony of defendant's expert, Dr. Marie Russell. The court asked, as in Judge Bev asked, quote, so, just to be clear, the Commonwealth does not intend, if I permit the testimony, the Commonwealth does not intend to call him, Crosby, in your case in chief, ? The Commonwealth responded, quote, absolutely not. So you guys see, Judge Bev asked the prosecution, so he's not going to be an expert witness for your case in chief, right? He's basically only going to be a rebuttal witness, right? And the prosecution said, absolutely not. He's not going to be a witness for our case in chief. He's only a rebuttal witness. So as we continue reading, however, the court's March 6 order contained no such limitation on the scope of Dr. Crosby's testimony for the Commonwealth to call him only as a rebuttal witness. So you see, guys, the defense team is holding the prosecution accountable, because even though the prosecution said we're not going to call Crosby as a witness to our case in chief, he's only going to be a rebuttal witness, the March 6th order contained no limitation, as in Dr. Crosby could testify for the Commonwealth's case in chief. He's not going to be just a rebuttal witness. You see, continuing, due to the lack of a memorialization of the Commonwealth stipulation, the defense reasonably assumed that the Commonwealth could call Dr. Crosby in its case in chief should it choose to. For the first ever time in writing and after receiving the report of Lieutenant Wing in its renewed motion, the Commonwealth states that it, quote, intends to offer Dr. Crosby only if necessary to rebut the testimony of Dr. Marie Russell, end quote. Commonwealth renewed motion. It's an attachment. Continuing, the defendant intends to call Lieutenant Wing as an expert witness in her case in chief. Lieutenant Wing's decades of knowledge, skill, training, and experience, together with his documented methodology, qualify him on the subject of dog-inflicted wounds on humans to cure any perceived complaints by the Commonwealth with Lieutenant Wing's original report. The defendant will provide an amended report of Lieutenant Wing, which will remove all references to Dr. Crosby. The defense expects to provide this amended report to the Commonwealth within the next 5 calendar days. As the defendant intends to call Lieutenant Wing as an expert witness in her case in chief, the discussion of law on page 2 of the Commonwealth's renewed motion is inapplicable, and they cite the motion. Continuing, this notwithstanding, and in reference to the Commonwealth's incorrect assumption that the defendant intends to call Lieutenant Wing as a rebuttal witness to the testimony of Dr. Crosby, the Commonwealth states in its renewed motion that, quote, there is no sub-rebuttal in Massachusetts courts. Continuing, the statement is accompanied by no authority and it is incorrect. Hoffman versus Houghton Chemical Corp. In parentheses, allowing surrebuttal witnesses, quote, the judge limited Halton to one surrebuttal witness only. So you see, guys, the defense is calling the prosecution on their bullshit, because in the prosecution's renewed motion, the prosecution stated there is no sub-rebuttal in Massachusetts courts. And yet here is the defense citing surrebuttal witnesses in Massachusetts case law. Good job, defense team. In parentheses, again allowing surrebuttal witnesses, quote, on surrebuttal, Brown testified that 2 Walkmans were returned to him after his arraignment, end quote. In fact, expert witnesses are explicitly allowed to testify in surrebuttal in Massachusetts. See Commonwealth versus Brown. In parentheses, quote, a defense surrebuttal expert who examined the same test results reached a different conclusion and testified that Brown was not malingering. Commonwealth versus Benson. In parentheses, quote, the defendant was allowed surrebuttal by a psychologist who sought to undermine some of the premises on which the Commonwealth's expert had relied in reaching his opinion that the defendant was criminally responsible, end quote. Therefore, even if the defendant did intend to call Lieutenant Wing as a surrebuttal expert, there is no Massachusetts law the defense could locate that would prohibit her from doing so. Indeed, there is contrary law in her favor on the issue. Excellent work from the defense, proving yet again that the Commonwealth is lying. Continuing, in conclusion, for the reasons set forth herein, the court should deny the Commonwealth's renewed motion in limine to exclude expert testimony of Garrett Wing. The defendant intends to call Lieutenant Wing in her case in chief, not as a rebuttal witness. As of the court's March 6 order allowing Dr. Crosby to testify as an expert, experts are no longer required to be medical doctors to testify about the medical causation of injuries. Lieutenant Wing's decades of knowledge, skill, training, and experience, together with his documented methodology, qualify him on the subject of dog-inflicted wounds on humans. Finally, and in the alternative only, surrebuttal witnesses are allowed to be presented in Massachusetts. For these reasons, the court should deny the Commonwealth's motion. Respectfully submitted for the defendant, Karen Reed, by her attorneys, Robert Alessi. Excellent work. Alan Jackson, Elizabeth Little, David Yannetti, April 2nd, 2025. Excellent work from the defense. And guys, this court document is yet more proof, more evidence of Hank Brennan's constant misrepresentation to the extent that Hank Brennan will misrepresent things that will directly impact how Judge Bev is ruling, how she is making her decisions on all these motions. So, it sucks that the defense has to be on their toes, because of the bullshit coming from the prosecution. But great work on the defense. This is an excellent motion. I commend them, and I respect them for taking care of Karen Reed. They are guardian angels battling evil. Thank you for watching.